John, for folks who are not familiar with this issue and the court's ruling, what happened?
Well, as you know, and a lot of people in the Valley know, short-term rentals are either a point of controversy or certainly a hot topic. And people have engaged in short-term rentals for a long period of time, especially with the rise of places like VRBO and some of the vacation rentals. So um, in response, homeowners associations started adopting rules which prohibited people from engaging in short-term rentals, and they defined it in a number of ways, but essentially anything less than 30 days. The issue arises is that the state legislature in 2012 adopted a provision in the civil code which said if you owned your property and were able to rent before an HOA adopted these rules or provisions, you're exempt from any of those prohibitions. Now, the HOA response was, we're not prohibiting you from renting. You can still rent just on a month to month basis. But that's not really, well, that's not what the Court of Appeals said the law stands for. It was a little ambiguous as to whether it applied to anything that prohibited renting or if it applied to people being able to rent at all. And the Court of Appeals decision says no, any rule that has the effect of preventing somebody from renting, whether it be short term or long term, they're exempt under this civil code provision and they're allowed to rent as they had done before the rule went into effect.
So the bottom line here is if somebody's living in an HOA, mine, for example, that does not allow less than 30-day short-term vacation rentals, if they were in that community before that rule was enacted, they're exempt?
Correct. Yeah, if when you bought your house, you were able to rent on a short-term basis, then you still can rent on a short-term basis, and that rule would not apply to you. Now, anyone who buys their house afterwards, so they're buying knowing that that rule is in effect, it doesn't help them at all. It only helps those people who owned their property prior to the adoption of this rule.
I would imagine this is going to have a big impact here in the Valley because there's so many communities like that people
Well,
lived in before this rule was enacted.
correct. And this is we've had several cases involving this particular issue, and uniformly the HOAs have always taken the position that the statute doesn't apply to what they deemed as regulations or restrictions on short-term rentals. Now, all of those all of those issues are the court has ruled against them and said that it does, and that's going to probably affect a majority of the homeowners associations in the valley because a larger percentage of them have adopted these rules to try to prohibit short-term renting.
You know, Sean, every time I do a story or an interview about short-term vacation rentals, I always get bombarded with emails, very strong opinions on both sides. People either love them or they hate them. I'm not partial to either side, but I imagine that this is going to just create a whole nother can of worms now because this issue is not going to just go away like that. People are going to be fighting this, I'm sure.
Well, they will, but they're going to be fighting with less ammunition than they had before. Now, one thing I want to point out is this is a tentative opinion by the Court of Appeal. It will become final once we have oral argument and they issue their final opinion. It's very, very unusual for the court to reverse their tentative decision, so I don't expect that to happen. Once it becomes final, though, people may try to push hard to prevent short-term rentals, but they're not really going to be able to. This will be the law, and people that own their house prior to the adoption of such a rule are going to be able to continue to rent their property on a short-term basis. The other thing that associations have tried to do is try to characterize the short-term rental use as a commercial enterprise. And many CCNRs have provisions in there that prohibit people from conducting business out of their house. But those rules were designed for people that are, have a hair salon, a nail salon, where customers are coming in, a retail store, where they're actually operating a business out of their house. And one of the things the Court of Appeals said in this decision is short-term rentals do not qualify as commercial, that type of commercial activity. So if you try to prevent short-term rentals by characterizing it as commercial activity, you won't be able to do that because that's not the type of commercial activity that's prohibited by these rules. It's no different than someone renting it on a month-to-month basis. They're still collecting rent, and you can't say that in that situation it's not commercial, but in a short-term situation it is.
I know that the court ruling was just a few weeks ago. Do you think most HOAs are aware of this ruling, or is this going to be something that is just going to be brought up on a case by case basis and HOAs are just going to be surprised when they find out that really this is not allowed?
Well, presently they're probably not aware because tentative opinions don't get published to the public. So I would imagine that the attorneys representing the association in this case probably have brought it to the attention of other HOAs that they represent, but it won't become more generally known to the public until the court issues its final decision, because they had indicated it will be certified for publication because it's the first decision to interpret this statute. At that point, it will get statewide distribution, and presumably associations will become much more aware of it at that time.
And I'm sure that we're going to hear a lot more about this when that happens. All right,
Probably will.
we appreciate your time. Thanks so much for joining us.
Thank you. I appreciate it. Bye.